Judge Mersel, please take the podium to continue our first session on judicial activism and judicial restraint. Thank you.
Thank you very much. I would like to begin by thanking the conference organizers for kindly inviting me to participate in this conference. As mentioned earlier, I was clerk of Justice Barak and later on his legal advisor, and I'm really honored and privileged to be here today honoring Justice Barak. The topic addressed by this panel is judicial activism or judicial restraint. I will start by saying that it appears to me that Justice Barak, if he was asked, would react somewhere dismissively. His standard reply to questions about his own activism throughout the years was, "Tell me how you define activism, and I'll tell you if I'm an activist." With this in mind, it seems to me that President Barak never admitted to considering himself an activist judge, nor did he ever deny being one. What is more, addressing the subject of activism in his forward article in the Harvard Law Review, he said explicitly, and I quote, "In any event, I am not at all interested in whether my legal community thinks that I am an activist judge or that I show self-restraint," end of quote. This having been said, I do believe there is room for further discussion on the topic of activism. Indeed, few, if any, would challenge the degree of preoccupation with this question of whether or not Justice Barak has been an activist judge and in what respect. On my words today, I will address the issue by making 4 points. First, Aaron Barak has an activist image, even if he was not necessarily an activist judge. Second, it is not surprising that Barak has an activist image. His writings regarding judicial discretion and the surrounding rhetoric created such an image. Third, it is not surprising that Barak has an activist image. Aaron Barak himself would probably define himself an activist. Fourth and last, is it possible that Barak truly wasn't activist, as his image would suggest, but that there were advantages to him being thought of as such? I'll start by focusing on Barak's activist image. Is it only an image, or perhaps a reality? The difficulty in addressing the issue is first the lack of a clear definition of activist judge. Even without such a definition, many scholars in Israel and beyond have come out against what they consider to be Justice Barak's excessive activism. There are those who argue that the Supreme Court is overly activist with regard to its review of other branches. Yet others argue against the broad use of reasonableness doctrine. Then there are those who condemn the lack of uncertainty and stability, and others who complain about the death of formalism and the rise of uncertain value-laden elements. It is also important to remember and point out that there were also many who were convinced that Barak's activism was well-founded, appropriate, correct in degree, and most legitimate. We may summarize this point by concluding that Barak has at least an activist image, but is it only an image? It is worth emphasizing that when Justice Barak's judgments are measured by their objective results, that is to say, to what extent he actually interfered with the other branches using judicial tools he created and developed, the result is not as activist as the literature would have us think. Let's remember, Barak sat at the court for 28 years and decided thousands of cases. The vast majority of these by no means interfered with other branches. Furthermore, a survey conducted in Israel in 2010, examining to what extent Supreme Court justices decide in favor or against the state, produced surprising results. The survey, touching on the judicial years 1995 to 2004, found that when Justice Barak's decisions are examined, his are relatively and almost the ones that tend to be most favorable towards the state. Hence, Barak, it turned out, was not all that activist if we apply a result-oriented test. Moreover, alongside the activist argument directed at Barak stands the pacifism argument. There are certain specific areas in which he is said not to have been successfully activist or sufficiently activist. For example, in the area of the High Court of Justice review of the administrative territories, or in the realm of social and economic rights, and the list can go on. Indeed, it is difficult to argue with the fact that Barak developed an activist image, without which it stands no reason neither he or we would be addressing the topic here today. What is far less clear is whether he was in fact an activist judge in reality, as his image would suggest. If we are in fact dealing essentially, or perhaps with a myth of activism, we can legitimately ask why such a myth was created and who created it. There were clearly those who disliked Barak's ruling for the result, and one might assume preferred to label him as activist in order to better attack his decisions. I would like to point out two interesting arguments relating to Barak's activist image today. The first argument is that perhaps Barak brought the activist image upon himself by developing his theory on judicial discretion. The second is that Barak himself, if asked, and as mentioned earlier, would probably define himself as activist. Let me explain. I'll start with Barak's theory of judicial discretion. There are very few judges who dedicated so much thought and writing, both in case law and in academic writing, to the topic of judicial discretion. Justice Barak dealt with this subject even prior to his appointment. He wrote in his 1987 very known book titled Judicial Discretion that the question haunted him already as he was a student. The book features a number of bold concepts I suppose most of us know, such as the idea that any text requires interpretation, that the authorized interpreter is the judge, that in his interpretive world the judge can and must examine the underlying purpose of the text and not only the simple words, that in examining the purpose, the judge is not confined to the framer's intent or to the framer's interpretation, and that the judge can and is indeed authorized to turn to the legal system's basic values when determining the said purpose or deciding between various objectives. Barak explicitly admitted that there are difficult cases in which choices involving some degree of subjectivities was inevitable, following an interpretive process, a decision that reflects the objective values as he identifies them. The ideas expressed in the book Judicial Discretion were rapidly implemented in Barak's rulings and rhetoric. A typical Barakian judgment would include chapters such as the underlying values, the objective purpose, the principal balance, the margin of interpretation, etc. Hence, Barak not only developed a comprehensive and sometimes disputable theory of judicial discretion, he had actually revealed his own decision-making and judicial discretion in his judgments. In doing so, Barak displayed exceptional intellectual and judicial honesty. He fully exposed the interest he was examining in his decision-making process. He systematically laid out the considerations at hand, the weight that he assigns to each and every interest and right, the manner in which he interprets the text, the exact weight he attributes to the legislative intent, if at all, and the version according to which he arrives to the result. This honestly was expressed with an exceptional transparency. However, and perhaps not surprisingly, this intellectual honesty exposed Barak to sharp criticism. The more transparently and systematically he presented his decision-making process, the more activist he came to be seen, and the more intellectually exposed he grew. Indeed, and unrelated to the issue of Barak's own activism, there is no doubt that Barak's theory respecting judicial discretion is activist, if only in the sense that they recognize a wide margin of judicial discretion. It is a most powerful approach in terms of judicial tools that it grants to the judge. The question of whether the judge will use these tools and to what extent is secondary to the impression of activism that the doctrine creates. Hence, Barak's theory and practice of judicial discretion has significantly contributed to his activist image. I personally truly doubt that Barak's cases, decided exactly the same way, would have attracted an activist label absent this transparency and intellectual honesty. In truth, Barak's honesty cost him, so to speak, even if in part, the label of classification as activist. Even if this was not his intention, this was the end result. But Barak's activism image does not rely only on his theory of judicial discretion and its implementation in his rulings. Another explanation I would like to suggest, and this is my second argument, is that Barak has contributed to that image himself by another way, by actually defining himself as an activist. Hence, If we would ask Barak himself if he following his own definition of activism, the answer would probably be yes, that he is an activist. Let me explain this shortly. Even though Barak did not like that much to debate over his activist rulings, he did try to define himself what an activist was. Already in 1987, in his mentioned book on judicial discretion, he turned his mind to the question of what constitutes judicial activism. He began by noting that the very idea of judicial activism or judicial restraint is only relevant to the extent that a judge has judicial discretion. That is to say, the ability to choose between two or more alternatives. On this basis, Barak determined that he defined an activist judge as one who understands the alternatives open to him and chooses that which advances the law, versus a restrained counterpart will select that which preserves the current state of law, the status quo. Barak further added that a judge who wishes to adapt the law to the realities of life is not necessarily an activist judge, for at times, an activist judge will not have that goal in mind, versus the restrained judge, in certain instances, will preserve the status quo in light of such realities. Against this backdrop, Barak felt that most of the existing definition of judicial activism focus on the end result and whether they are satisfied with it accordingly. Barak viewed the fixation with judicial activism as leading to unhelpful double standard with respect to public confidence in the judiciary. In his updated definition on activism, 27 years later, on 2004, A Judge in Democracy book, Barak added that an activist judge is not only one who is undeterred by changing the existing policy or overturning the case law, but, quote, in order to achieve certain goals, is prepared to develop new judicial tools, such as new interpretive methods, ways of properly deviating from stare decisis, that will allow him to change the law, end of quote. And what about methods of interpretation? Barak notes the absence of a direct link between the interpretive method of choice and whether or not a judge is an activist. Seen from this angle, purposive interpretation is not necessarily activist, and an originalist approach is not, by definition, restrained. Barak admits that on the balance of probabilities, we are more likely to find activism on the side of the objective interpretation. That is because this form of interpretation gives the judge more room to maneuver, which serves the activist judge. And in the end, Barak observes, the activist judge will tend to broaden standing and narrow non-justiciability. He will develop new remedies. He will prefer principal balance to ad hoc classifications. So, is Barak activist according to the above-mentioned tests? It is difficult to hide from the fact that the more we explore Barak's writings, the more we get the impression that if Barak were to be asked he was activist, he would answer in the affirmative. Barak developed and fleshed out the theory of purposive interpretation. What is more, he developed various judicial remedies and tools, expanded standing, and narrowed non-justiciability. He expanded the grounds for reasonableness and proportionality. In truth, according to Barak's own definition, there is not only one characteristic of an activist judge, but they are chiefly characteristic of an activist judge. Were we to examine Barak's 88 years at the court, his activist traits overweight those Barak would deem passive. In his book, Barak does not conclude whether, according to his own definition, he is indeed activist. He leaves the answer somewhat open, essentially suggesting that he may have been activist at times, but not always. That having been said, and as noted, if we are to examine all the criteria that Barak himself exposed, and even if we were to conclude that his assessment that judges are only in part activist or restrained, it still appears that these tests reveal his own record as being more activist than passive. What conclusion can we therefore draw from all of the above? Is Barak's judicial activism in fact only a myth? It is unlikely that Barak was not aware of his own activist image, But was the gap between the activist image and the reality entirely coincidental? It is truly hard to say. Barak himself was fond of saying that we should focus on analyzing the case law, not on psychoanalyzing the judge that drafted them. But we might still inquire into whether Barak's activist image was at least beneficial. And this is my last argument. An intuitive argument, and perhaps one that Barak would give if asked, is that this image harms the Supreme Court and its status. The activist image creates unnecessary strain between the court and the other branches. It attracts excessive criticism of the court and its work and creates an inaccurate impression of its role among the public. In the long term, it can harm public confidence in the judiciary. There is, however, another possible explanation. This explanation would suggest that the activist image did not harm Barak or the court, but actually helped them to secure their status and role in the Israeli democracy. Broadening the rules of standing, relaxing justiciability, and developing the doctrine of reasonableness are tools that gave the court a powerful image. They expanded the array of cases in which the court could potentially intervene. Thus, even if the court did not actually intervene, it came to be perceived as both powerful and influential. Why was this so important? Indeed, it is important to remember that the Israeli legal system is relatively young. Israel is a young democracy. It is a divided society that does not have an entrenched constitution even after 63 years of independence. The relationship between the government branches is sometimes tense, as is the relationship between cultural and ethnic communities. There are security challenges, and the threat of terror, as we've seen just a few days ago, constantly looms. Against this background, the court's status and that of its judges depend not only on formal constitutional or statutory interpretation, but mainly on the judges themselves, on the rulings, and on the public confidence in them. Paradoxically, one can argue that in the above-described state of things, it is better to have judges perceived as activists even when they are not. It is far better that the government branches know that they are subject to judicial review, even if the court ultimately does not intervene. Indeed, Montesquieu's theory of checks and balances might take into account an additional component, that of the judge's reputation as an activist judge. At times, that reputation is no less important than what the judge actually does. A judge's mere reputation as interventionalist and activist, irrespective of whether she actually is, can in itself constitute a powerful tool. And what happened with the passage of time? Is this activist image still of benefit? Over the last years, we have been witnessing a prolonged and increasing attack on the Supreme Court of Israel. These attacks, significantly intensified after Barak's retirement, were accompanied by calls to reduce the court's power and to change judicial appointment process. What sparked this change? There are many factors responsible for this change. One is that certain actors dedicated what they understood to be a decline in the court's manifested power, as evidenced in its activist rhetorics. Thus, we seem to witness what might best be described as a backlash against the activist myth. It stands to reason that some of the reactions and critiques directed at the court were promoted by a perception that it created an activist reputation, even though in practice, this intervention is limited. It might be that we were witnessing a realization that in the absence of a strict constitutional and a long-standing democratic tradition, the court's actual power was limited relative to the other branches. The process we are perhaps witnessing over the last years is one in which the court is losing its activist image while being exposed to call and initiatives to narrow and limit its powers. It is perhaps in this context, related to disparity between the court's activist reputation and its actual record, that we can come to understand Barak's comment in an in-depth media interview that took place after his retirement from the bench and in the midst of the bitter attacks on the Supreme Court. When asked by the reporter whether, if given the chance, he would do things differently, if he would have been more cautious and a reserved judge, Barak replied, I quote, "I would have done a great deal more could have been achieved, a lot more should have been done." It might be that in a retrospect, Barak regrets the fact that he was only perceived as an activist and was not truly activist in reality. Thank you very much.